Welcome to my channel, All for Health with Jane. Family, we are still on the AKA and Tibz murder case. Now we are focusing on accused number 4 for his application of bail. Family, remember, accused number 4 is the alleged coordinator, the alleged junior mastermind, the alleged organizer of the whole hit. He's the one, the 800,000 rands was deposited into his account. He's the one who distributed the monies to the other accused persons. So, family, I don't think it's going to be easy for this one to be granted bail, but anyway, God loves us all. So, family, let's watch and listen as his legal representative is presenting his matter to the court.
Your Worship, I intended in my address to deal with applicant number 4's application for bail under two headings. One, exceptional circumstances, as in circumstances peculiar to him. And the second, and my submission is that exceptional circumstances must also be looked at in conjunction with the state's case. But I'm going to depart from that. And I'm going to address Your Worship's concern, well, I presume one of them, that Your Worship raised with my learned friend for applicant number 1, the bank statements. Now,
it's not only that, I was raising that to Advocate Lodger because he touched on it.
Yes.
As far as I'm concerned, there's more than that when it comes to applicant number 4.
Yes.
But I will address that as we proceed.
Yes.
You may proceed.
Thank you. So to deal with the bank statements, Your Worship, the simple reason why not all bank statements are attached is that applicant number 4 simply did not see a need for it, didn't see the importance thereof.
Now, how can that be when the talk of the day and the talk of the century is the 800,000 amount that was deposited? And why exclude or omit that amount when it is the subject matter?
For the simple reason that it's not disputed. So it's not disputed he received 800,000 rand. It's not disputed that he paid out sums of money. It's not disputed. Now, Your Worship should be aware that for the state to say, oh, we don't know his bank statements, that's an untruth. I'll tell Your Worship why. If Your Worship considers Annexure KP1 to the state's affidavit, Your Worship will note it's a collation drawn up presumably by the investigating officer. Now, he could only but have drawn up that collation if he had access to the applicant's bank statements and bank accounts. That's the first point. The second point is easy to subpoena them, and he could have done so. But, Your Worship, it's rather disingenuous of the state to say.
This is the applicant's case. He is the applicant in this matter. He is presenting circumstances and facts which support his application. Why should you, in your application, rely on someone else's information when you are in a position to present that information yourself?
We don't. We're not relying upon it. The 800,000 rand is common cause, and we see no reason to take that any further. He says in his affidavit, I paid them out, received the monies for business purposes, and I paid it out. Let's not forget the beauty of it, for the applicant going first, is that the respondent gets to investigate it. There was a good deal of time between the applicant's affidavit and that of the respondent's. So they could go and investigate it. But Your Worship sees nothing dramatically to the contrary to what the applicant says in his affidavit. So, Your Worship, my submission is that really disposes of the issue of the bank statements. But can I take this further? So, Your Worship, exceptional circumstances. It's a question that is much easier to ask than to answer. And I'm sure when Your Worship interrogates the state, you will ask the state, well, what do you think exceptional circumstances are? What are exceptional circumstances? There are a multitude of cases dealing with exceptional circumstances and a person's personal circumstances. But my submission is, one thing is for sure. It could not have ever been the intention of the legislature that exceptional circumstances are the exclusive territory of circus acrobats and double amputees, because hardly anyone would get that. Your Worship just needs to take cognizance of S versus DV. It's referred to in my head. Just to quote one line. Your Worship, it is page 5, paragraph 23.
Page 5.
Paragraph 23, Your Worship.
Page 5 is paragraph 12 to 14.
My heads of argument, Your Worship, is page 5, paragraph 23. Indebted to my learned friend, it seems that some of us have pages one bit differently. I can't really explain it, but page 8.
Page 8.
Page 8.
That is where paragraph 23 is.
I beg your pardon?
That is where paragraph 23 is, on page 8.
Thank you, Your Worship. So if Your Worship looks at the second paragraph of the quotation from S versus DV, it would be futile to attempt to provide a list of possibilities which will constitute such exceptional circumstances. To incarcerate an innocent person for an offence which he did not commit could also be viewed as exceptional. So that then, Your Worship, takes me to applicant number 4's personal circumstance. Let's start with his arrest. The police raided his house. He wasn't there. Contact was made with his attorney. He surrendered himself the next day. He was supposed to have been at the police station 9 a.m. He arrived in the afternoon. Not the actions of someone who wants to run away and evade arrest. That also would not have been in the mind of the police, because I recall from the states found in affidavit that his home was under surveillance, and I think somewhere in that affidavit they say one of the team even spoke to him. Now, if he was a flight risk and he was going to run away, one must wonder why that member of the team didn't arrest him then and there. But be that as it may, he surrendered himself to the police. So now let's look at his personal circumstances. He has 2 wives, living in 2 different residences. One residence is rented, and he himself lives in the house with, let's call her his first wife, the doctor, and that house is the subject of a bond in the wife's name. So my submission is, he has a permanent address, no indication of him living elsewhere, and then he's got business interests that derive his income. He has children who attend local schools. My submission is that he is grounded in the area of jurisdiction of this court. Now we look at the offence. The problem is, Your Worship, in a bad application, as Your Worship knows, we're not entitled to the statements in the docket. We have to rely on the candour and transparency of the investigating officer. So let's analyse what he says in respect of accused applicant number 4. But bearing in mind, as Your Worship said, this is not the trial court. So we don't have to answer each and every contradiction, each and every little thing. Because as your worship said, not the trial court. However, let's deal with the 800,000 rand. Common cause, he received the 800,000 rand. He informed the court via his affidavit where he got it from.
Affidavit.
Why does your worship say that?
Because the source, safe to say that from a reputable company, it does not state who the company is.
Very well, your worship. Let's not forget that the state had the ability to follow the trail of the money. And in fact they did.
But again, he is the applicant. He is supplying the information.
Yes, your worship.
For that information
Correct.
to assist his application.
Except in this instance, it is perfected by the state's investigation. So the state has unwittingly corroborated what he's had to say. He said that he got it from a reputable company. The state has then informed the court that the payor was Mfundu Kaba through one of his companies. Now, the last time I looked, if you pay, as the state has alleged, for a hit, you are as equally guilty as the person who receives the payment for the hit. But the payor is not amongst these accused. It was raised on the last occasion, still not arrested. Why could that be? The state categorically said, number 4 was paid 800,000 rand for a hit. They know who paid the money, but he's not arrested. The only conceivable reason why, bearing in mind everyone is equal before the law, is that there is no evidence to back up that claim that he was paid 800,000 rand for the hit. There's no other explanation for it. By virtue of the fact that the police do not arrest the payor, in fact the payor releases a press release that confirms what applicant number 4 says. Now that then does away with or weakens the state's assertion in respect of the 800,000 rand. So now all we have is applicant number 4 receiving 800,000 rand in the course of business. He says it's in the course of business. The state investigates. They can't find anything to suggest it's not. The only complaint is, well, how do we know he got value for it? No indication of value. Now, the simple fact of the matter is, as your worship sits here, and your worship knows, having been on the bench many times, the state doesn't have an automatic, a more beneficial route for the court to believe than an applicant does. Both sides are equal before your worship, notwithstanding the applicant has their own. It's a charge and the balance of probabilities. So that deals with the money. Now we can interrogate that all we want, but as your worship has said, this isn't the trial. The second factors are the motor vehicles and the cell phone. Now, what the state does is they only present a small fraction to the court. And they say he hired the Polo, he hired the BMW for purposes of the vehicle. Not so. Vehicles were hired before that. And before he changed to those vehicles, other vehicles were hired. But that is not put before your worship. And in fact, it's not significantly gainsaid either. So that explains really the motor vehicles. Then the remaining issue, break it down, is the cell phone. And they say the cell phone puts him in the vicinity. But they don't tell your worship what the vicinity means. They don't tell your worship what the range of the vicinity is. We are here in this court. Could it extend as far as North Beach? Could it extend to the entrance of the court? Could it extend to the door of this court? You aren't told, sir. The state does not take the court into its confidence. So, what do we have? We have 800,000 rand And the businessman says, I paid him the 800,000 rand for business purposes. And that businessman is not arrested. We don't have a shooter amongst them. We have an extradition process in another country where they are trying to bring back two accused and to link them. And with all due respect, the NGA doesn't have a good record with extradition. So where does that leave this case? My submission to your worship is the following. One of the criteria, and I do not hang my hat solely on this criteria, but one of the criteria is if you can demonstrate on the balance of probabilities that you would be acquitted. And I would submit to your worship, if this is the evidence, and your worship is confined to this evidence, not what might happen, this bail application and your worship's ruling is confined by a snapshot in time. And that's the evidence that we have now that both sides have put before your worship. And on this evidence, I would submit accused 4 will not be convicted. Whether he's put on his defense or not, well, that's another discussion. 174 closing the case, be that as it may. But as I've said to your worship, I do not hang my hat solely on that. My understanding of exceptional circumstances are you can take particulars that are particular to the applicant, and you can look at that in conjunction with the evidence against him. And when you put both of these in the basket, so to speak, it allows a court to make a determination on exceptional circumstances. And it doesn't have to be specifically restricted to either the state case or the applicant's case. So, Your Worship, in a nutshell, those are my submissions. But once again, as Your Worship has said, this isn't the trial. So, Your Worship, subject to my reply to my learned friend, and of course, subject to Your Worship has indicated many concerns, that is my address.
Yes, I've got a few questions.
Yes.
Or rather concerns, not
Yes.
questions, because you are not a witness, you are not an accused. But please assist me, because I've got these concerns.
Yes, Your Worship.
In his founding affidavit, applicant 4, paragraph 47, if I'm not mistaken. Yes, paragraph 47.
Okay, with Your Worship.
Yes, and if one reads that together with all right, let's start with paragraph 47. In paragraph 47, he states that he has a security for himself and for his family.
Yes.
He was at some point in time seriously attacked. Is he safe?
Yes, Your Worship. There is no indication that he's not. He simply explains.
Or security?
He simply explains what happened to him in the past and how he came to use the services of other individuals. The state does not say any degree of certainty that he is unsafe. and the simple say-so of an investigating officer without it being backed up by evidence in respect of anything.
No, it's the applicant himself saying that.
Yes, Your Worship. He explains. He says some time ago. And that was on a visit to the mine which is in, I think it's in Mpumalanga, Your Worship.
Because standing trial does not only mean flee, but it means not being eliminated whilst you are out.
Correct. So that the interests of justice can be fulfilled.
Yes.
Yes.
So that is why I'm asking myself this
I
question.
understand,
That is why I have this concern.
Yes.
Is he safe if he's outside?
So let me allay Your Worship's concern. Yes, he is. As he said, it was some time ago and it was on a trip to the mine. Let us not lose sight with respect, Your Worship, that the court is always open to, or can, impose conditions. And the court is able to eliminate any concern that it may have, or the states, by the imposition of conditions. And if, for example, the court is concerned that if he visits the mine, his life may be in danger, we don't want him killed, want the trial to reach an end, Your Worship is free to impose such a condition.
Paragraph 57 of his affidavit. I wish to be clear, I do not recall in driving, I suppose he wanted to say, I do not recall driving BMW,
Yes.
nor was I driving it on the day that deceased were killed as alleged.
Yes,
What is he saying?
exactly that, Your Worship.
I do not recall.
He's saying, I don't remember driving a BMW.
I deny driving BMW.
Yes, he says, I wasn't driving it on the day that the deceased was killed either. But now, of course, the question is, Your Worship, as Your Worship has mentioned, how far do we interrogate the evidence? Well, this is not the trial. This is bail.
Well, it's relevant to ask this question in light of the allegations. He does not say in no uncertain terms, I deny driving. I do not recall.
Yes.
There is a difference. If I understand correctly, I deny driving the BMW on the day in question,
Yes.
as opposed to I do not recall. I do not recall driving the BMW.
Well, then, Your
Is
Worship
there
will
a
allow me
difference
to-
or not?
If Your Worship will allow me to break it down.
Yes.
The day that the deceased is killed, that's a day that generally an individual will recall more readily than an ordinary day some time ago when asked later on, what did you do on Thursday, the 20th of April? I couldn't tell Your Worship if you asked me. So I think that paragraph needs to be read in that light. But once again, Your Worship, how far do we go into the merits of the state case against an accused in a bail application when this isn't a trial?
Yes, I agree with you. I agree with you, but the concerns have to be raised and interrogated, because if he took the stand, he was giving viva evidence. He would have been cross-examined and he would have accounted. But in this case, we are faced with an affidavit which cannot be cross-examined.
Absolutely, Your Worship. And the investigating officer would have been cross-examined all day.
Exactly.
You say 800,000 rand was paid for a hit, but you don't arrest the person who paid the 800,000 rand. Why not?
But
It cuts both ways.
right now, we're not talking about the investigating officer. We're
No,
talking
Your
about the applicant number 4. Let's wait until we get to the investigating officer.
Your Worship, please.
Yes. Let's wait until we get to the investigating officer and ask those questions to the investigating officer.
Thank you.
Right now, we're talking of
Yes.
the applicant in this case, who bears the duty to show on the balance of probabilities.
Yes. Exceptional circumstances.
So let's not jump to the investigating officer as yet. Paragraph 63.
Yes, Your Worship.
The state alleges that applicant number 4 was requested to submit his cell phone.
Correct.
And that request was extended to his attorney as well.
Correct.
According to the state, I don't know, I was not there.
None of us were.
Otherwise, I would not be sitting here.
Yes.
Applicant number 4 refused.
Yes. That is
And
what the state says.
can I finish?
Sorry, Your Worship.
And applicant number 4 says in paragraph 63, all the exhibits the police would like to use against me to prove the charges are in possession of the state. And yet there is these allegations made by the state, the cell phone which we have requested a number of times from the applicant and from his attorney, we're not in receipt of that. He refuses to submit that.
I hear Your Worship. But Your Worship will no doubt have regard to his response to that. And that is, I don't have it. It was at home. The police raided my home. Your Worship has been furnished with the USB showing the beginning of that raid.
But that is not contained in his reply in affidavit. That reply you are giving now is not contained in his reply in affidavit.
Your Worship will bear with me.
Show me if I missed it.
I may have a moment, please.
Certainly.
Reply and affidavit.
That is exhibit M.
Page 10, Your Worship.
Page 10.
Paragraph 52, Your Worship.
No, it cannot be paragraph 52. Page 10 has paragraph 28 and paragraph 29.
I apologize for that. Can I take Your Worship to paragraph 52 then? Hopefully the paragraphs have remained the same. To ensure that Your Worship and I are on the same page,
Yes.
literally, it's the paragraph that says much is made.
Page 17.
Thank you, Your Worship.
Yes, thank you very much. I missed that. And
Your
it
Worship,
is stated here, counted. Much is made of the alleged failure to hand the cell phone to the police. This is untrue. Yes, no, that is accounted for.
Yes, Your Worship, please.
Thank you for There are allegations by the state that applicant 4 was the coordinator
Yes.
of the hit
Yes.
man.
Yes.
He was the mastermind.
Yes.
That suggests, or the suggestion by the state is that this was the work of a gang.
I've read that, Your Worship.
Yes. Now, if that is true, I'm not saying it is true, it is an allegation, will that not cause a stir in the public?
No, Your Worship. Firstly, an allegation that has been denied by the applicant. Secondly, it's always been my submission that there is no one more optimistic than an investigating officer for a prosecutor. So no, that allegation is denied. Furthermore, there's no evidence, not a bit of evidence put before your worship to indicate that if your worship, for example, granted bail, there would be a public outcry. There is nothing. No evidence. Only a submission, not based on anything factual.
On his replying affidavit, applicant number 4 state among others that the state case is just a conjecture.
Yes.
And there is no substance in the state case. Now, my question is, there is evidence in the affidavit by Pillay that he was found in possession of the witness statement, the original witness statement in his vehicle in the car behold, the witnesses that were to testify about the vehicles.
The BMW, when it was taken by the police for
It's
investigation.
two witness statements. I'm not looking at Pillay's statement right now, but there are two witnesses whose statements were found in his vehicle,
Yes.
cabby hole.
Yes.
Now the question that begs is, what are the state's witnesses' statement doing in his possession or in his cabby hole?
Well, Your Worship will recall that the BMW was taken by the police, was taken from a third party. Obviously, accused number 4 is then has to then explain, well, you had the BMW, it was taken from these people, or taken from investigation. So I would submit there is nothing unnatural in trying to get to the bottom of it. And in fact, if anything, it indicates a tendency to want to cooperate with the police.
But wait a minute. Let's look at Pillay's affidavit. I'm not saying he is telling the gospel truth. Whatever he's saying is true. But let's read and understand it. Witnesses XY approached me and asked for their statements. At the time, I did not know why they wanted their statements. It's only later on that I learned that they asked for their statement from me because such statements were demanded and asked for by applicant number 4. Yes. That is what Pillay is saying.
Yes.
Whether he is truthful in saying so or he is making up the case, I don't know. But that is what is contained in his affidavit. So if it is true, what is it?
Well, Your Worship, I'm not in a position to argue, make out an argument based on the investigating officer telling the truth when our affidavit says something different.
But you had an opportunity, if I say you, I mean you on behalf of applicant number 4, you had an opportunity to reply. Did you reply to that? If you did, take me to that particular
Your Worship, bear with me. Your Worship, I'm not going to mention pages because I'm getting them wrong and I'm not on the same page as Your Worship. But I'll take your worship to paragraph
Paragraph
56.
56.
And while we're in that, on that paragraph, your worship, my instructing attorney is not the attorney made mention of them. Different attorney.
You say paragraph 56.
56, your worship. Paragraph 56, and it starts, the heading is ad para 234.
But paragraph 56 speaks of the affidavit that your client made to the police. I'm not talking about that.
No, your worship, but this is his reply to what Pillay has said, and incorporated in that was what your worship made mention of.
Okay, so you say that is the answer.
That is the
to,
answer.
To my question.
Yes, your worship.
Okay. You're not under cross-examination. You're not supposed to be answering the question. You are assisting me to allay the concerns.
No, of course, your worship.
I accept what you're saying.
So, your worship, that is his answer.
Okay.
But once again, my submission is it doesn't impact on his application for bail. It is not an indication of tampering with evidence. It is not an indication of intimidating witnesses. And it's not an indication of destroying evidence or that he will abscond. Even if your worship were to accept the investigating officer's affidavit, as your worship calls it, as the gospel truth.
No, but wait a minute.
Yes.
Since when is a suspect entitled to witness statement?
Well, your worship, under circumstances.
Before those statements are given to him by the state.
But he wasn't the suspect then.
I beg your pardon?
He wasn't the suspect then. We're not talking about statements from this docket, your worship.
One other thing that raises a question
Yes, your worship.
is the allegation by the state that his cell phone places him at the airport, it places him at the scene of the incident when it occurred. His cell phone places him at the garage in Umlazi, where, or rather at Umlazi, where the vehicles used and the weapons were returned.
Yes. And your worship's question is?
Does he address that
Yes, he
in
does.
his reply?
Yes, he does.
Okay. Assist me.
So, paragraph 13.
Is this now his reply affidavit?
Correct, your worship.
Paragraph 13.
In fact, 13 and 14.
Yes. I think we work better if we speak of paragraphs than pages.
Yes, indeed, your worship. Paragraph 15 and 16. Paragraph 20 and 21. Paragraph 22. paragraph 41. I think that is all, Your Worship.
Thank you. You have referred to, I think, KP1 of Pilay's.
Yes, Your Worship.
Looking at that consolidation, can you confirm that the money is paid in, that is the 803,455 rand is paid in at 1400 hours at 2:05, so to say?
Yes, Your Worship.
And,
that is what this annexure says.
Yes. And the large portion of that amount is paid out at 8:05. If we look at the last entry to St. Benedict School.
Yes, Your Worship, but Your Worship is forgetting at 18 hours 22 and 19 hours as well, which are monies were paid out between that time. So basically, I hear Your Worship, I understand where Your Worship is coming from, between 6 o'clock and 8 o'clock.
Is that within a short space of time,
Correct.
we calculate 2, 3, 4, 5, 6, 7, 8, within 6, 7 hours,
Yes.
this large amount is paid out.
Yes. But that is the nature of the applicant's flow of money. Sometimes he gets large amounts, and then there are lean periods. Look like advocates, we're poor one day and wealthy the next day.
I'm just noting that because you refer.
I understand.
Thank you very much.
As Your Worship pleases.
Family, this application of accused number 4 was the last one in court, as we are waiting for the state tomorrow to present their their arguments, the reasons why they still feel, even after the legal representatives have presented all these reasons, they need to give us why they feel these 5 people must not get bail. So we will hear that in the next video. Thank you very much, family, for watching. Please like this video before you leave. Subscribe for my channel if you haven't done so yet. I love you very much, family. Thank you. Bye.